the 15th Amendment does not guarantee the right to vote. Rather, it merely says that the right to vote shall not be denied on account of race. As a result of this wording, Southern states were relentless in passing laws and policies restricting the ability of African Americans to vote. One common early trick was to pass voting laws containing grandfather clauses. Grandfather clauses only allowed people to vote if their grandfathers were eligible to vote. This restriction didn't mention anything about race, but of course, few black citizens were eligible to vote because their grandfathers had not been eligible to vote. For example, shortly after Oklahoma was admitted as a state, it passed a law guaranteeing the right to vote only to people whose ancestors were eligible to vote on January 1, 1866, which was 4 years before the 15th Amendment was adopted. Individuals who did not meet this criterion could only vote if they passed a difficult literacy test. States justified this policy by saying that they only wanted people with deep roots in a community, people who were deeply invested in its future, to decide a community's fate. They denied that race was a motivation. The fact that black people couldn't vote was just a coincidence. Fortunately, the Supreme Court saw through this ruse, and it declared this law unconstitutional in 1915. Regarding the argument that the law was race-neutral, the court said, "It is true it contains no express words of an exclusion of any person on account of race, color, or previous condition of servitude prohibited by the 15th Amendment, but the standard itself inherently brings that result into existence, since it is based purely upon a period of time before the enactment of the 15th Amendment, and makes that period the controlling and dominant test of the right of suffrage." But Southern states weren't finished. Many states, including virtually every state in the South, required people to pay a tax in order to register to vote. While these laws applied to both black and white citizens, the burden fell more heavily on African Americans. But this time, the Supreme Court would not come to the rescue. It decided that poll taxes were constitutional in 1937. In 1964, the 24th Amendment was adopted, which prohibited poll taxes in all federal elections. And 2 years later, the court reversed its 1937 decision and declared poll taxes illegal in state elections. Today, one ongoing political battle is whether states can require voters to present a valid form of photo identification before they vote. Some critics charge that this constituted a poll tax, since states usually charge a fee to issue identification cards. Today, however, all states that require identification before voting issue state ID cards for free to poor citizens. Nevertheless, such requirements do tend to discourage voting among poor and minority voters. States adopted other methods of suppressing or diluting the votes of minorities. Two of these were white primaries and racial gerrymandering, which are discussed in other videos. They also adopted literacy tests, in which potential voters had to demonstrate their knowledge about political topics by passing a test before they could vote. The testing officials were invariably easier on white applicants than black ones. And, of course, they also frequently resorted to outright violence and intimidation to keep African Americans away from the polls. In fact, Southern states tried so many different ways of suppressing the black vote that it became like a game of whack-a-mole. As soon as the courts or the Constitution prohibited one way of discriminating, Southern states invented another. And they were successful. In 1964, only 19% of African Americans in Alabama were registered to vote. In Mississippi, it was a pitiful 6.4%. In 1965, Congress finally had enough. The 15th Amendment gives Congress the authority to pass legislation to enforce it. Drawing upon that authority, it passed the Voting Rights Act of 1965. The Voting Rights Act was a sweeping law that granted the federal government new power to oversee federal elections in the South and elsewhere. The Voting Rights Act banned literacy tests. But it did so much more. Two of its provisions were the most controversial. First, it authorized the appointment of federal examiners. These were employees of the federal government who traveled to the South to directly oversee and monitor the registration of black voters and the operation of polling places on Election Day. These federal examiners generated significant hostility, and 3 of them were murdered, as depicted in the film Mississippi Burning. The other provision that generated controversy was the preclearance provision. Because states had devised such ingenious ways of discriminating against black people without specifically discriminating on the basis of race, the Voting Rights Act required states with a history of discrimination to obtain approval from the United States Department of Justice before they could make any changes to their election laws or procedures. In order to receive approval, they were required to demonstrate that the change would not have the effect of harming minority voters. These provisions did not apply everywhere. They only applied to states or other governmental entities that had a history of discrimination in voting, as demonstrated by various historical or statistical benchmarks that were included in the law. For example, any state that had a literacy test was included, as was any state in which less than 50% of the adult population had voted, or was registered to vote, in November 1964. Southern states objected and filed a lawsuit claiming that although the federal government did have the power to enforce the 15th Amendment, this law had gone too far. The Supreme Court disagreed, and it upheld the law in a unanimous decision. The court acknowledged that the law was an unprecedented intrusion by the federal government into what had traditionally been a state responsibility. But it said that history demonstrates the variety and persistence of institutions designed to deprive Negroes of the right to vote. Despite the earnest efforts of the Justice Department and of many federal judges, these new laws have done little to cure the problem of voting discrimination. Even when favorable decisions have finally been obtained, some of the states affected have merely switched to discriminatory devices not covered by the federal decrees, or have enacted difficult new tests designed to prolong the existing disparity. After enduring nearly a century of systematic resistance to the 15th Amendment, Congress might well decide to shift the advantage of time and inertia from the perpetrators of the evil to its victims. And the law worked. At the time of its passage, all 13 states of the Confederacy were covered, but within 2 years, 9 of the 13 states had raised the percentage of African Americans registered to vote above 50%. It was so successful that Congress reauthorized and strengthened the law in 1970, 1975, and 1982. But conservatives have always hated the law, and in 2013, the Roberts Court handed down a decision that didn't declare the Voting Rights Act unconstitutional, but which rendered it completely inoperative. That decision and its aftermath are explored in the next video.